Highlights of editorial. India's data protection law needs refinement. Data protection in India was primarily governed by the Personal Data Protection Bill, 2019, PDP Bill. However, no progress has been recorded in terms to bill to law and its enforcement. The Personal Data Protection Bill, 2019 aims to regulate the processing of personal data and establish the rights of individuals over their data. It is intended to provide a framework for data protection and privacy rights for Indian citizens, as well as for entities that process personal data within India. Personal Data Protection Bill, 2019 include 1. Applicability. The law applies to both government and private entities that process personal data in India or are involved in profiling of data subjects in India, as well as certain entities processing data outside India if they are dealing with data of individuals in India. 2. Data principles rights. The bill grants individuals, data principles, certain rights over their data, including the right to access their data, correct inaccuracies, erase data under certain circumstances, and restrict or object to data processing. 3. Data fiduciary and data processor. The bill introduces the concepts of data fiduciaries and data processors. Data fiduciaries are entities that determine the purpose and means of data processing, while data processors process data on behalf of the data fiduciaries. 4. Data localization. The bill mandates that certain categories of sensitive personal data must be stored and processed within the territory of India. Additionally, critical personal data may also be subject to data localization requirements. 5. Data Protection Authority. The bill proposes the establishment of a Data Protection Authority of India (DPA) to oversee and enforce data protection laws. 6. Consent requirements. The bill emphasizes obtaining explicit and informed consent from individuals before processing their personal data. It also provides provisions for handling data of children. 7. Data breach notification. The bill requires data fiduciaries to report data breaches to the DPA and affected individuals promptly. Data protection laws are subject to change, and new regulations as per requirement are enforced. The European Union General Data Protection Regulation, EU GDPR, is a comprehensive data protection law that came into effect on 25 May 2018. It is one of the most stringent and far-reaching data protection regulations globally and applies to all EU member states, as well as organizations outside the EU that process personal data of EU residents. EU GDPR includes 1. Territorial scope. The EU GDPR applies to organizations that offer goods or services to EU residents or monitor the behavior of individuals within the EU. 2. Lawful basis for data processing. The regulation requires organizations to have a lawful basis for processing personal data. 3. Individual rights. The GDPR grants various rights to individuals over their personal data, including the right to access, rectify, erase, restrict processing, data portability, and object to certain types of data processing. 4. Consent. If an organization relies on consent as the lawful basis for data processing, it must be freely given, specific, informed, and unambiguous. Organizations must also make it as easy for individuals to withdraw their consent as it was to give it. 5. Data Protection Officer. DPO. Certain organizations must appoint a data protection officer to oversee data protection practices within the organization. 6. Data Protection Impact Assessment. DPI organizations are required to conduct a DPI when data processing is likely to result in a high risk to individuals' rights and freedoms. 7. Data transfers. The GDPR imposes restrictions on transferring personal data outside the EU to countries or organizations that do not ensure an adequate level of data protection. 8. Penalties. Non-compliance with the GDPR can result in significant fines, which can be up to 4% of the organization's global annual turnover or 20 million euros, whichever is higher, for the most severe violations. The EU GDPR was designed to strengthen individuals' rights, increase transparency in data processing, and harmonize data protection laws across EU member states. It significantly impacts how organizations handle and protect personal data and places a greater emphasis on data privacy and security. Now coming to the questions that could be asked from the above editorial. Why called India is called No Europe? India is called No Europe because Europe Union framed protection law imposed and enforced from 25th May 2018. However, India still did not have proper discussion over the bill. With reference to Indian Data Protection Bill law policy, establish relationship between the Indian administrative reforms, government and non-government policies. Reason out the various shortcomings of India Data Protection Board. Critically analyze that India is APT to establish scientifically and technically advanced in terms of Indian Data Protection Bill law policy. What are various Indian provisions, laws, acts to safeguard individual data?